seconds to go for his rebuttal. And it does not appear that the judge is letting them go over for any sake amount, any time. So here we go.
He was waiting down the block for him. Y'all remember the testimony. What Armando said is he stopped his vehicle and got out and walked the back of the vehicle and checked on Arlene. That's what he was doing. Isn't it funny how all three lawyers told you don't base this on emotion? And then they all talked about emotion. They all want you to be emotional about this defendant. They all say, you got to feel what he was feeling. You got to understand what he was feeling. Ed is yelling. Anna is soft. And Anthony is accusing me of impropriety. But don't base your verdict on the emotion. Life is emotional. But if you notice, the evidence we brought you was not emotional. It was analytical and it was logical. We can't escape the reality of what this case is. Emotional for everybody. I want to address a couple of things that they said first. The law allows me to respond when they talked about not bringing the homicide detectives. And Mr. Oso suggested that they must not agree with the case. This is the way, and I'm allowed to say this as a response. This is the way this works. If any police officer or any homicide detective involved in this case disagreed with it, I'd be obligated ethically to tell them. And they would have brought him. So that is just not true. The reason why you didn't hear from homicide detectives is because this case wasn't a whodunit. Besides interviewing the defendant's wife, there's nobody else to bring you. They seized surveillance video. And so what we did is we brought you the facts in the case so you could know what happened. There's no better evidence than that. It's funny, they always complain about too many cops. Now they're complaining there's not enough. Y'all can know the evidence. I want to talk about this though. It's like they were saying, oh, well, you know, we're not disputing they shot in the car. Well, these are the shots. First, they claimed he shot first. Then they claimed the lack of muzzle flash was because the robber got some kind of special bullets. Y'all remember that, right? Well, now we know.
Objection mischaracterizes the evidence.
Same instruction. You heard the evidence. You guys get to determine what the evidence is based on the testimony and the witnesses on the stand. You may continue.
And now they still are going on the video from across the street. They did it again in argument. You see, they're crossing paths, so of course it's reasonable for them to think that he got in the car. Remember, what the law says is you're in the defendant's shoes, not in his mind. The defendant would never have seen them cross paths. We know that. He goes into the dark of night and he starts shooting into the next vehicle. But they keep showing that, so you start thinking that it was reasonable. And it was not. Maroon was right. This is actually very simple. Y'all can go back there, and the sole issue before you, is it reckless to shoot into a vehicle when you can't see in? Period. Hard stop. That's the decision. And we all know that's the case. But don't base it on emotion. You notice what they do? They keep calling him Tony. Tony this, Tony that, Tony that. It's Mr. Earls. A 9-year-old is called by her first name. And seems like she's kind of been absent from this trial. It's all about him. Let's talk about him. His wife was clearly fearful. At that moment, they were being robbed. They didn't know what was going to happen. We all know that. But he got out of that vehicle angry. He got out of that vehicle, make no mistake of it, and the law allowed him to do it, is he could have shot that robber and killed him for the property. But make no mistake of it. Y'all can start debating this back in the jury room. That man decided he was willing to kill somebody over a wallet, 20 credit cards, and $20. That's what was in his mind. He was already ready to kill. But then once he does the shots, he doesn't get back in the vehicle and flee. He then goes to that open space, angry, and he starts shooting at the next vehicle. And that's the sole issue before you. Is shooting into a vehicle that you can't see in a reckless act? And we all know it is. We don't have to prove he knew Arlene was in there. If he knew Arlene was in there, he'd be charged with capital murder and would be facing the death penalty. All we have to prove is it's a reckless act. It's not justified to shoot into the vehicle when you can't see the occupants. You know, there's been some talk about this robbery suspect. There is a suggestion somehow that this robbery suspect is responsible for Arlene's death. And make no mistake of it, would have loved to have captured him. But it isn't his actions. It's his actions that caused the death. And it helps you to know that that was rather probably not either a real gun, 2, a gun without bullets, or 3, if it was a gun with bullets, he had more restraint than anybody, because as he's being shot at, he's not shooting.
Judge, I object. That's a mischaracterization of the evidence.
Same instruction, tired of repeating it, you heard the evidence.
But that didn't matter to Tony Earls. To Tony Earls, it was worth killing. And he did not care. You know, we talked a lot during jury selection about guns in our community. And some of y'all on this jury are into guns, and that's a good thing. Some of y'all are not, but you respect those who do. And folks who carry guns, we all know there comes a responsibility when you choose to arm yourself. When you choose to purchase a weapon and have it on your person, you are responsible for your actions. And yes, the very laws that give you the right to kill to get your property back, the very laws that allow you to defend yourself, is also the very law that protects the Alvarez's family. Because you know there's a right in our community that we haven't talked about. There is a right for a family to drive in the Gulf Gate area to a pizza parlor. There is a right for a family to be able to drive down the block on Valentine's night. Have you thought about that? the day of love, and they're driving to dinner. They have a right to not have that man fire into their car because he's pissed off. Make no mistake of it, that man was not fearful anymore. That man decided he was angry and he was going to do something about it. And not only that, he was willing to kill everybody, even if he thought the assailant, the robbery suspect, had gotten into the car. Have you thought about? He was willing to kill not only the robbery suspect, but anybody he was in the car with. Have you thought about that? Because he didn't care. And you know that because after all that, when he's looking out and he sees Armando, he shoots in that direction. Again, jeopardizing everybody behind Armando and his family into an intersection. And they want you to believe that that was reasonable. They sold you that again. See, guys, if y'all just see that he's passing the car enough, even though it's not my client's perspective, maybe you'll believe he's reasonable. It's in his shoes and in y'all's mind. That's the difference. You don't get into his mind. His mind is angry and unreasonable. It is your
Objection,
mind.
that's a misstatement of the law.
You guys have the jury charge. That's the law in the case. Refer to it.
They showed you this again. Again, trying to affect you with not the facts according to this defendant. I'm going to show you 108 again because it is so important. And there was a suggestion that, yes, he did have a couple of seconds, but you know what? He didn't even think. He just started firing. There is nothing more powerful I can say or words I can string together that are more powerful than what you just saw. What you saw was not an accident. True, it's a tragedy. But a little girl is dead because of the actions of this defendant. And Maroon is absolutely right. When you read that charge and you get to page 6, it tells you that in the course of all this, if you recklessly cause the death of an innocent third party, you go to the verdict room. How else can you interpret this evidence? And it's a reasonable person standard. Yes, you put yourself in his shoes, but you get to say what is reasonable. Most of y'all would never have even gotten out of the car. The rest of you, had you gotten out of the car, you would have
Objection
gotten
and proper argument.
back in the car. It's a reasonable person standard.
Once again, you heard my instructions with respect to what they say not being evidence that comes from the exhibit and the witnesses. You may continue.
Judge, for that particular one, and we have a rule.
So we will, you have 7 minutes and 53 seconds.
It's a reasonable person standard, so you have to ask yourself, would I have even gotten out of the car? If yes, that's okay, you're justified. But after that, would you have gotten back in the car?
Objection, Your Honor, invading the province of the jury.
Look at the charge, y'all decide. Sir, you understand the rules, please continue.
And
Judge, we have a ruling.
That is sustained.
lastly, you certainly would not have shot into a motor vehicle where you couldn't see into it. And if as a result you kill somebody, an innocent third party, you know you're responsible. We have talked this entire trial about Tony Earls. We actually, it seems like it's lost, that a child lost her life. Have you thought about what the interior of that truck was like as this was going on? I'm going to play you the audio, or we're not going to see anything. And as you listen to it, I want you to think about it. That when he is firing those 3 shots, he is firing at someone's back. I want you to think about when you hear shots 4 and 5, I want to remind you of Armando's testimony that when he turned the gun to us after the robber, I thought he was going to shoot Wendy and I. So then he speeds up when you hear the sound of his tires. Then you're going to hear 6, 7, 8, and 9. And when you hear the 7th one, you know that's the one that hits Arlene. Then there's going to be some silence. And you're going to know that's when he gets out of that vehicle to check on his daughter. But in that silence, I want you to remember what Armando told us. Everybody was screaming. Armando Jr. was screaming, "My sister's been hit. He's got blood all over him." When you hear that silence and whatever they're trying to say is 5 gunshots down the block, I want you to think about that moment. armed with the law. Considering all of that, this should be the easiest decision because it tells you no matter what was happening out there, when you recklessly cause the death of an innocent third party, you're guilty of manslaughter. And can there be anybody more innocent than a 9-year-old child? She is sitting in that picture on Valentine's morning in the seat in which 14 hours later she would be dead. You heard the medical examiner tell us that she was shot above the right eye
2 minutes.
and that the bullet fragments were in the back of her head. What we know from that is when Armando tells us she had her headphones on and he yells to his family, "Get down," she doesn't hear it. But there's a difference between someone yelling in a car and gunshots ringing and you can hear it. So she looks as they're passing and she's looking at the man who would kill her. She is looking at the man and the barrel that would cause
Objection,
her
there's no
death.
evidence of that at all.
How else do you interpret that the shot happened above her right eye as she's looking outside?
Excuse me, Your Honor.
Stop.
I asked
You have
the
an
jury
objection.
be instructed to disregard this last comment.
Disregard that last statement. You may continue. You have 2 minutes left.
You were next. This is why you are here. To put an end to this. And to finally hold this defendant accountable for his actions. And Moon and I now give it to you. Go back in that room and bring justice.
I've read you the charge. You've heard arguments. Please go with the bailiff. At this time, you can start your deliberations. One shot in the room. Also, lunch is here. They'll explain the rules with respect to how you can deliberate with lunch, without lunch.
All rise for the jury.
Okay, Ms. Roxanne.